Julia.
Yeah.
Sorry, we cut our training short. If you have time before you leave, we can walk through it one more time.
Okay.
Just like
I think it'll be okay.
but you'll just basically do everything you did. You have to clock out.
Should I clock out now?
Yeah. And then
Oh my God, my brain froze.
and then everything has to get plugged back in, yeah.
Okay.
And then this one's in the drawer.
Okay. And then
Recording in progress.
Hello. I can't hear anyone. I think everyone's on mute.
Yeah, that's okay.
There you go. I can hear you.
Yeah, we're just trying to get all these other things set up. Yeah. Okay, whoops. So you can hear me, right, Dean?
Yep, I can hear you.
Oh, here we go. I'm gonna get rid of that. If you could help them figure out how to set up, that would be great.
Where are they watching? Right here?
Yeah, I'm trying to set this up so I can make it bigger.
Just in the way. I don't know where you're going.
There we go.
Oh,
So then see, they can see from here. And then Dean and I will.
in the video, that's why. Yeah.
Oops. So I set this up over here so it's in the big screen. So people can see from there. And then I set it up so whoever is speaking, oh shoot. I left all my questions in my office, but I can wing it because I know lots of questions.
And we practice.
And we practice, so copyright.
I'm gonna stop my video because there's no point in me.
Yeah, right. Yeah, that's fine.
We haven't quite started, so get settled.
Yeah, we just want to make sure everything works and you can hear us and see. Oh, hi, so this is Dean Wang.
Oh, hi.
This is Rebecca. She's one of my clients that you answered the question about earlier.
Yes, thank you for that.
I'm sure we'll have lots of questions today. I guess I should point this here. And then I was gonna unfuzz my thing so people can see the shop. There we go. Then people can see the shop. But then you should be, you won't be able to see the audience because she turned off her video. But that's okay.
We don't need that
Yeah.
audience necessarily. I don't know that everyone wants to be recorded, that's why.
Yeah. Well, they'll be so far away. So how many are gonna be on joining us online?
I believe 4.
Okay. So we have a good in-person presence, Dean.
Great.
So this is awesome.
Phones can be silent if possible.
4 more minutes. So for the, oh, look who's here, Foster. Hi, welcome. So yeah, I'm so glad you guys came. So for those of you who have not been to one of our live events before, basically in the beginning, I dialogue with the speaker, just talking back and forth questions, some of the things that people have been asking. And then at some point in time, I'll stop, and if anybody here or that's on Zoom wants to ask a question, can feel free to do that. That sounds good. So, hello, how are you,
Hi.
Gray? You came back.
Yes, I
You must like us.
always did.
Yeah. And what is your name, sir? Roger, nice to meet you. Are you one of the vendors here? You're not. Okay. What brings you here then?
I understand we're going to talk about intellectual property.
Yeah, we are.
That's a good subject to learn more about.
Oh, awesome. Good. We're glad to have you here. Maybe we have 2 minutes, so maybe we could go around the room.
Yeah.
So I'll just introduce myself. I'm Robbie Melton. I'm the Center Director for the Small Business Development Center here. We do no-cost business advice, advisory services. Somewhere are the flyers. So we have 2 events coming up, one in September called Starting a Business in Hawaii. And then in October, we're going to have Accounting for Creatives. So anybody,
And then we also have these.
oh yeah, and then our flyer is there if anybody's interested. Maybe we'll just put these out here for today. And then, yeah, so Liz, why don't you start in the back and introduce yourself and what brings you here?
I'm Liz.
Oh, speak up so Dean can hear you.
Oh, okay. Hi, Dean. I'm Liz Stevens. I actually help Robbie with small business development stuff here in Kaua'i. So I just joined in today. That's all about.
My name is Roger Jacobs. I started a business here on Kaua'i in 1992 called Data Space Industries. And I spend most of my time being creative, either creative problem solving or multimedia development or inventing gadgets or whatever. So I'm interested to hear what you have to say.
Right. Great.
Hey, I'm Grace Galisa, Financial Services with Mai'kai, and I also do complementary financial needs analysis. So
Great.
I hope you'll come see me.
Thank you.
My name is Rebecca Carnate. I'm here. I want to know a little bit more about what he has to say today about patent and about a product. I'm trying to patent something and I need some answers with some of my questions that I think you've already answered.
Foster.
Hey, I'm Foster Brown, owner of Focus Energy and the director of a new nonprofit that we just started with an initiative to help underneath people get access to help and services around their house or anything they need for their business. Yeah, just came to help in any way I can and learn a little bit more about what's out there.
So I met Foster at the Kaua'i Community College Strive Entrepreneur class, which is for an entrepreneur class for veterans.
Hi, I'm
Yes.
Laura Finelli, and I'm one of the vendors here at Alakoko, and I do painting and artwork. So I'm trying to learn as much as I can about turning this into a business, so that I can make my art my business. So I'm still very much in the learning phases, but that's it.
And then do you want to introduce yourself, Crystal, since some people here may not know you?
My name is Crystal, and I'm the project director of this Alakoko shop, which is under Rice Street Business Association. And I was fortunate enough to meet Robbie, who decided she was on board with doing this once a month small business mentorship program in collaboration with our shop to try to reach out to our small businesses, maybe a new business, maybe someone who's growing. But it's always nice to just have that resource available, especially on an island like Kauai. It's sometimes hard, especially if you have more what you feel are private questions, or like you'd rather be face to face rather than hunting online for all these answers. So hopefully you guys can get some kind of benefit of these mentorship programs.
You want to introduce yourself?
Oh, hi, I'm Holly. I just started a business, Holly Hollinger Art, which is watercolor, and then I turn those into digital images and make stickers and cards and prints. And I'm with Crystal on Alakoko for, I think, going on 7 months now.
We started like
5 months?
January, so
Yeah.
I
So a
think
while.
February is when you came on board.
Yeah, it's been great.
Cool.
Very cool. So just so everybody knows the format, Dean and I will do a dialogue. Like I said, it usually runs till 4. Might go a little bit longer if you don't mind, because I know there's some questions. Excuse me. And then afterwards, we'll just all hang out, Hui. We can all just talk and, have a discussion about business, whatever needs you might have. Let's see here. So Dean, I don't know if let me change my view so you can see Dean better. There we go. Yeah, so Dean, oh, there you go. That's better. Thank you. Can you hear me okay?
Yep, I can hear you.
Okay, great. So as you know, so Alakoko is this great shop with all these vendors, and we have a lot of people who are artists. And one of the big questions I get all the time is, how do I copyright my artwork, whether it be a painting, greeting cards, photography? What's the way to protect it from other people doing the same art?
Okay, yeah. So the good news is that copyright exists the moment something is created. So by law, the minute you create your painting, you make your video, you write your song, whatever you create, the minute it's put into a media, paper, electronic form, whatever the medium is, a copyright is automatically created by law. So that is the good news. So you don't have to do anything special. That the minute you make it, it is yours. You have the copyrights to it. But there's a second portion that people talk about, is registering your copyright. Now there's a whole system with the federal government where you can go register your art and get a copyright registration. And you might want to do that because in order for you to sue somebody for damages, you need that registration. So there's some costs and benefits of it. It's a time-consuming process to file for the copyright. But the good news is that once you create something, it is yours. You own the rights to that. And what that means is you have the right to prevent somebody from using it, from copying it. You have the right to prevent someone from taking your art and creating what's called derivative works. You write a story, but then somebody takes your characters and then write their own story. You have the right to exclude them from doing that. And that exists the minute you create your work.
Right, so we talked the other day about the only time you would need to maybe do a formal copyright as if someone actually maybe infringed upon your artwork, and then you would do a formal registration. Is that correct?
Yes, yeah, you do a formal registration or you do it ahead of time, and then that will allow you to sue, receive certain types of damages under the Copyright Act.
But what about, so I've seen like other famous artists where once they created their art, they're not actually duplicating the art, but they're using the style of art. Is there anything about that, or is it just, well, that's it?
Yeah, so you're talking about a person who is imitating somebody else's art and copying the styles. Yeah, that area, it's a little bit more of a gray zone. If you are a company and you have a certain type of style, and somebody that copies that style, that person could be infringing on what is called your trade dress. So an example would be the Tiffany blue, and for Tiffany jewelry. Tiffany jewelry comes in a distinctive box, has a color that is very unique. Tiffany actually has a trademark on that color. They're one of, I think, only like a dozen companies in the world that actually have a trademark color. And so if somebody were to start a jewelry company and start using that color on their jewelry boxes, but they don't like Tiffany, they put their own name on there, they would be violating, infringing upon Tiffany's trademark, because there is a distinctive look and feel to what Tiffany is doing there. And if somebody copies it, it would create confusion in the marketplace because people might think that this person is selling something from Tiffany's, but they're really not. And then those cases, the person who originally created this look might have a claim. In Tiffany's case, they definitely would have a claim against somebody who is infringing upon it. So in your case, if this artist is always doing a certain type of look or often does a certain type of look that has become well known, and that a person who knows art sees the style and said, okay, yeah, I know that artist because that artist is known for this type of style, then the artist might have a claim against somebody who is copying that style. But it has to, the artist really, it has to be unique. It has to be unique to the artist, meaning that it hasn't been done before. Other people aren't doing this, it's not a common technique. It would have to be associated with that artist's brand. So this is what they do. This is how they always do it. And somebody is trying to imitate. So yeah, they could have a claim in those cases for what is called a trade dress, which is a type of trademark.
So a lot of times you see people do something either in print or like I've seen people who create artwork and they put the little C with the circle. Does that mean it's already copyrighted, or is there a need to do that little circle, C in the circle?
Yeah, there's you don't have to do it. It's really just putting people on notice that, hey, I'm not giving anyone any permission to copy or duplicate or make derivative works out of my art without talking to me first. So it avoids any sort of misunderstanding, because there could be art out there that is subject to a different type of license, like a stock photo, for example. Stock photo generally can be reproduced because the person who created that stock photo has sold it to a company who says, okay, everybody who subscribed to my photo collection can use this however they want. So in that case, you would have put a copyright on there because you don't own a copyright to it. But if it's your original work, it helps to have that to say, hey, this is my original work. You cannot duplicate this unless you talk to me first.
Great. So you got into a little bit about trademarks. So that's always the other big thing. Can you talk about when you would trademark something or when can't something be trademarked?
Mm-hmm. So yeah, trademark, I guess, first I'll just make a distinction. There's trademark and service mark. I'm going to use the word trademark generically. Technically, a trademark is for a product. A service mark is for a company's business. So this would, like my Luminate Law here, would be a service mark, not necessarily a trademark because it's not a product, it is an identifier of my business. But I'm going to just use the word trademark generically to encompass all these things. So a trademark is something that you should get if you have a distinct, a distinct name, logo, or slogan where you want the right to be able to sue somebody if they infringe upon it or create something that is very similar. So Nike has Just Do It. They sue everyone on the internet who does something, do it. They go after everyone. They enforce their trademark, and they do that because under the law, if you have a trademark or you have a name that you consider proprietary, if you don't enforce it, if you don't send someone a demand letter or sue someone, the law will consider that you will deem it that you have given it up, basically, that you have waived your rights to your proprietary rights to the logo, and that you don't want to enforce it on anyone, so it's free to the public. So you want to get it if you want to have something that you're afraid that somebody might steal or try to create something similar, and you want to be able to exclude them. But of course, having that trademark registered means that you have to endeavor in the process of finding people who might be infringing and sending them a demand letter. And that is part of the responsibility of owning a trademark.
So when I had my company, we tried to trademark our name, which was Women in Bio, but the Patent and Trademark Office came back and said no, because it was too common or too similar, even though nobody had our name. Can you talk about that?
Yeah, so in that case, you probably didn't get the trademark because the words were considered generic. So you cannot trademark words that are generic unless they are put in a certain way that makes them distinct to your brand. So Women in Bio would be considered, they probably considered it as generic because women in general, you can say Women in Bio, and it can be used in a generic sense in day-to-day language. You also can't trademark something that's considered descriptive set of words. So, for example, I wouldn't be able to trademark a red car, the word red car, because it's just describing a car that's red, and it's not unique. So if you want to trademark something, it has to be unique in a certain way that clearly identifies your brand. That's not something used generically in the public. It's not descriptive. So a lot of companies, especially tech companies, come up with their own words. They just make up words because a made-up word is not generic. A made-up word is not descriptive. It's just a made-up word. And not just tech companies, but just other companies. And one common example is Haagen-Dazs. Haagen-Dazs is a made-up word, completely made up. It sounds fancy European, but it's does not from any language. It's just a made-up word, and they wanted that so that they could trademark it. Nobody else used that word before because it's a made-up word. You can get it makes it easier to get a domain name because you don't have to fight for somebody that might have a domain name that's similar to yours. So it's helpful to have that. The downside might be for a small business owner, if you use a made-up word, is that you might not get SEO traction on your website as well. If your name has some words that people might search in Google, it might pop up easier than if it's just a generic name.
I wanted to bring up, you mentioned before about that in order to comply also with the trademark that's why they send all these letters. So if you neglect addressing this also makes it not compliant, or what was that you had explained before?
Yeah. So if you own a trademark, you have to enforce your rights. And enforcing your rights means, sorry, my 1-year-old's outside my door trying to get in. Enforcing your rights mean sending letters to people who infringe on your trademark. And that means sending out a letter to someone who might have a similar name to yours and tell them to cease and desist. And by doing that, you're preserving your rights to that trademark. If you don't do it, then the law will consider that you have waived or given up your rights to your trademark because you've stopped enforcing it.
But you also made a good point the other day that it has to be a letter from a lawyer, not from
Yes. Well, legally, it doesn't have to be from a lawyer, but you should get a lawyer to write it because these are things that have legal effects, affect your legal rights to your business, to your trademark. And it should be demand letters are generally done by a lawyer. So demand letters are letters where basically somebody's threatening to sue someone if they don't do X, Y, and Z.
So when talking about trademarks, so when I was a seed investor, people who created products claimed they could protect their product by trademarking it, but you really need a patent, right? You can't just trademark a product.
Right. So patent. So if you think of protections for something you've made, they generally fit into, I would say, 4 categories. So trademark is like identifier of a business, service, or product. Copyright is the right to the artistic work that is created. You wrote a song, you made a video, things like that. And then patents is the, excuse me, the right to a design and invention. So yeah, if somebody invented a product, they would want to get a patent for it. And so a patent allows you to create that invention and exclude other people from creating that invention or something derivative from the invention that you created. So that's a patent. And the last category would be called trade secrets. Trade secrets is generally the category that something would fall into if it doesn't fall into the first three categories. Trade secret is something that you as a business that you keep as a secret. It's a trade secret, which means that you have to keep it under lock and key. You don't let anybody know this. The most common example is the Coca-Cola formula. Nobody knows what the Coca-Cola formula, though you can probably guess what it is, but nobody knows exactly how it is. If you work for Coca-Cola, they don't tell you what it is. Only a select number of people know the exact formula. They have it stored somewhere in some safe somewhere. That is considered a trade secret. And if you were to take that, steal it, they would, as an employee or anybody else, they would sue you to, say that you've stolen their trade secret. So those are generally the four categories of protection that you have as a business owner when you have some sort of intellectual property.
So from my understanding, it costs a lot of money to patent a product. Can you talk a little bit about the patent costs and why it costs so much money?
Yes, yeah, patents can be expensive. Though I have a friend who started a company called dirtcheappatents.com. I think you can check that out. I haven't talked to him in a long time. He was one of my law school buddies. I've talked for like 14 years. But there might be some costs. There might be some shops out there with lawyers who do patents for a discounted price. But patent process is generally it is expensive because it's a process. And the first thing that has to be done whenever you do a patent or a trademark is that you should search the USPTO website, the Patent Trademark Office website, to see if somebody has patented or trademarked something similar to what you have. So the first step is to go through that process and figure out if there's something similar out there. And then if there is something similar out there, your patent application has to show why your product is different from the existing patent. And that means you have to have a list. A patent process requires you to come up with this list of all the functions of your product and the description of what your product is comprised of, and why it's unique. And also on top of that, a patent has to be considered non-obvious. And that's where some people also get hung up, is that non-obvious means that the person reviewing your file, the patent agent or attorney at the USPTO who's reviewing your file, has to make a determination that what you've invented is not something that would obviously occur by putting the things you're putting together. So an example of that would be if I took hot dogs and I took hot dog flour, hot dog buns, and I added mustard to my flour mix for hot dog buns, and I got mustard flavored hot dog buns. That would be obvious because it's obvious that if I add mustard to the flour of hot dog buns, it would create mustard flavored hot dog buns. So that's just an example. So that's something that's considered obvious, and you're going to be able to patent that. However, if I did that and it cured cancer, that would be non-obvious, and then I could get a patent for that. And that's sort of the difference. So you have to reach that hurdle. So there's two hurdles to reach. One is that whatever you're trying to patent can't already exist. And on top of that, whatever you're trying to patent can't be considered obvious under the existing science, the existing knowledge.
Okay. So one other thing, I know we're supposed to be talking about copyrights, patents, and trademarks, but since it's rare that we get an attorney to talk to us, one of the things that's been coming up a lot in my office are partnerships. And I always tell people run, because partnerships can get very ugly. Even though you think everything is copacetic in the beginning, maybe could you briefly talk, like what are some of the protections? Like, are there documents you can have when you start a partnership?
Yes. So if you're starting a partnership, you should definitely sit down with your partner and preferably with an attorney and go through different scenarios relating to your partnership. So if you form a regular partner, so a partnership, I guess I'll just start, if you and someone else do a business venture together, no matter what legal documents you've created, if you haven't created any legal documents, the law automatically considers it a partnership. And as a partnership, then that business arrangement is governed by the Uniform Partnership Act. There's a statute that governs that. Most people, when they get into a partnership, they'll create an LLC. LLC is a limited liability company, and an LLC is governed by an operating agreement. And the operating agreement is what governs the partnership and governs each person's right in that partnership. Some people might create a corporation. Corporation has bylaws and also another document called the shareholders agreement. Those are basically the bylaws and shareholders agreements. Basically, together forms like an operating agreement of an LLC, but they're considered two separate documents for corporation for historical and statutory purposes. So in those cases, you should have a sit down, because a lot of times people go into business. I've seen this many, many times. A lot of times people go into business with their friends or a friend, and then they go through the business process. But businesses can be stressful. You might not make as much money as you want at the beginning. It might take time to work. Sometimes people run into issues where they think the other person's not working hard enough, or the other person's supposed to do this and they didn't do that. And then disputes happen, and it works both ways, stuff like that. To help avoid some of these scenarios, a document should be created that governs everyone's rights. So what happens if one person dies? What happens if one person gets disabled? What happens if one person wants to leave the partnership? Who gets to decide what? What decisions require both partners to make, and what decisions can be done individually that doesn't need permission from the other partner. So those are things that go into an operating agreement. And by having this structure in place, it helps to avoid misunderstandings and conflicts in the future. And the thing about business partnerships is that they tend to, I call them business divorces, because they tend to emulate a real life divorce. And what happens is that there's a dispute, and the dispute keeps growing, and then it becomes a big mess. So in those cases, it's better to get ahead of it. And also, if you have a dispute, to resolve it quickly in a way, don't let disputes linger. Have a conversation and deal with it. Because if you don't, they tend to grow and they tend to get out of hand. So anyway, that's just my general advice from what I've seen with partnership. And also, I just want to throw this one piece out. There's a point in every business where partnerships, I call it sort of the point of no return, when there's a dispute in a partnership. And the point of no return is when both partners feel that the other partner is getting the better deal. So when you make your decisions about what happens if somebody dies, what somebody leaves, what management decisions, how somebody gets paid, all those decisions that you have to make in your business and partnership, do that at the beginning so that both people feel that it's fair. Because if it feels unfair, then often that creates a recipe for disaster. Yeah.
I think we had some online questions when people registered. Crystal, do you want to?
We had one, we kind of touched a little bit on it. It was, does posting a publicly time-stamped video of an artwork serve as adequate documentation to secure copyright?
So the copyright is created, whenever you create it, whether you create it privately or in a public place. But if you create it in a public place, and you have a timestamp, you have a video on it, that is definitely better than if you create it in your room and nobody knows about it. Because one of the things that the court looks into is whether what you've created has been published. So if it's been published, as in this case you've done it in a public sense, that is definitely better than if you didn't have any evidence. Of course, in those situations, you have to make sure that the way you're recording all that is in a good way that can be proved in court, because somebody might make the argument, well, you recorded it, but it's they stamped it, but you actually recorded it, later on, and this is a fraudulent video. So there's a possibility that you could get into some sort of fight about the authenticity of the video. But definitely it's better than not having a video. If you're worried that somebody's going to steal something, you can show a video of you creating that art.
Great, awesome. Did you have any other questions on that?
The other one was a very common one. We've had it multiple times, is LLC or a sole proprietor.
Yeah, so what's the difference? Like, especially if you're a creative, to me, and this is my thing, and you can definitely correct me, but if you're just creating jewelry, or not, I shouldn't say just jewelry, because that's but jewelry or something artistic, and the chance of getting sued is minimal, is there a reason you would want to do an LLC?
I always recommend an LLC for any business endeavor. And the reason is, when you create an LLC or a corporation or a limited liability partnership, those entities act as a shield against your personal assets. So yes, maybe you're doing something that doesn't have a risk of being sued, but there's always that possibility out there. If you don't have the LLC, then your personal assets can be taken. But if you have an LLC, then they can only sue the assets of the LLC and not your personal assets. So like in the case of jewelry, my lawyer brain is going to think, well, what if you used a metal that contains some sort of contaminant and they put it on and somebody gets an allergic reaction or some pollutant or whatever in their system or something like that, and then you get sued for it. Well, if you had the LLC, your LLC acts as a shield. They can't go after your savings account. They can't take your home. But if you don't have the LLC, then they can go after those things. So that's the risk. And LLCs are generally very easy to create. You can create one on the DCCA website. You just need to get the LLC. You get a generic operating agreement. You get an FEIN. You get a G license. There are some administrative requirements to it, but I generally feel that costs definitely the benefit outweigh the costs.
So somebody just asked, can nonprofits be sued?
Yes, nonprofits can be sued. Yes.
Yeah.
Everyone can be sued.
Wow. Okay.
I have a question. So with an LLC, there's some complications if you only have one person. Like typically you need a board, right?
No, you don't. Yeah.
No, not for an LLC. No, that's different. So how about the audience? We only have a few minutes. Does anybody in the audience have a question? Okay.
Can you give us a ballpark figure of how much it costs for a copyright trademark?
Oh, did you hear the question?
Yeah, ballpark figure or copyright trademark. So I talk about copyright trademark, but I actually don't do registrations for them. But if you have the inquiry, you can send to me, and I can forward you to somebody who specializes in going through and obtaining it.
Yeah, because I think each one is different depending on the complexity.
I noticed most lawyers don't like answer that question.
Well, I think because depending on the complexity, the cost varies. So
yeah, it depends on the complexity. It depends on, a lot of times the main issue is if whatever you were trying to get protection for is similar to something else that exists. So if it's similar to something else that exists, then there's some back and forth between your attorney and the office, or your attorney is going to try to find an angle to convince the office that no, actually ours is different and it's special for XYZ reasons.
Yeah. Anybody else? Grace?
Yeah, with his the nonprofit question. If a nonprofit is sued, how do they protect themselves?
So did you hear, if a nonprofit is sued, how do you protect them? How does the nonprofit protect itself?
Well, it really depends on the facts. I guess the first thing you should do is you should get a lawyer and have them look at your case. The other is that you should also make sure you have good insurance. That's for any business. Have good insurance that covers your liability. In the United States, if you're a seller of if you're a retail seller of any product, even if you did not design or manufacture the product, you can be liable for selling that product. So if you're selling stuff on the internet, have some sort of policy that covers have some sort of product liability policy that covers what you're selling. That is often better than having to find a lawyer later on to defend yourself from a lawsuit, because if you have insurance covering it, then your insurer will often provide an attorney able to walk you through the process if you get sued.
Is it a Hawaii law that all businesses have to have general liability insurance?
I don't know if I don't think all businesses, you should have general liability insurance of some sort, but I don't think all businesses have to have it. You might be required to have it if you have a physical space. But yeah, I don't know exactly, but insurance is something that I think every business should have.
Okay. Yeah.
General liability insurance is required if you're going to do business on a certain level.
Okay.
If you're just doing business with the community, all casual, it's not going to come up. If you want to do business with the state of Hawaii or larger companies, they're gonna want to see that before they make a deal.
Okay, all right. Any other questions? We're coming up to, yeah, go ahead.
We're a nonprofit based in Washington, and now we just got our licensing for Hawaii, and we're just trying to get familiar with where we can go to ask for donations and set up stuff to do fundraising. And a lot of the businesses just keep
You have to
throwing
talk louder so he can hear
Sorry,
you.
we just got all our licensing to be a nonprofit in the state of Hawaii, and we're having a hard time finding out resources for where we can go and set up to do asking for donations or fundraisers.
So there's a couple. So if you can set up a nonprofit corporation in the state of Hawaii. If you're looking for donations for that, people often will give donations and they get a tax deduction. And to get a tax deduction, you have to be a 501c3. So there's that's the federal filing. So if you've gotten form nonprofit at the domestic level, you should also file for the federal 501c3 to get the federal tax deduction, so that when people donate, they can take that deduction. So that helps generate some deduction. The other thing is also to know that whenever you solicit money in a state, you have to register generally with the state attorney general. So you go to the state attorney general's office, there's a form to fill out. You have to reach a certain dollar amount. So if you're brand new, you're probably not there yet, but at some point you probably will be. You have to make sure you register with the state and fundraise. If you're looking for general fundraising advice, start with your personal networks. Some people want to hire fundraisers, professional fundraisers, and that's one option. But I've also heard that be very careful who you hire to fundraise, because in some cases, some of those fundraisers charge more than you actually raise. So just be careful. Find someone who's reputable.
Yeah. Okay. One more question. Is there anybody online that has a question? Can you tell?
I see a call-in user, but I don't know if they have a question.
Yeah, there's nothing in the chat, so. Okay. Do you have any questions?
I think he answered.
Okay, all right. You guys in the back, you got a question?
Maybe, okay, I was thinking this, but I don't think it was a question, but I'll make it one. So if you find somebody that has what's it called, a patent or a copyright or a trademark, and you want to use that, is there any way you can approach that business and like say, hey?
Yeah, you can license the technology.
Okay.
If they're willing to do it.
Okay.
Yeah.
Make a deal.
Yeah, you just, make a deal. I can talk to you more about that. Yeah, that was my former life. Yes, sir.
There was a word that came up earlier, sounded like trade dress.
Trade dress? Did you say trade dress?
Yeah, trade dress, yes.
What is
So
that?
trade dress is the quote sort of look and feel of your business or the product. So if you look at on the screen here, I sort of have a trade dress here that our firm uses orange and yellow. So that can be considered like a trade dress. If you go to a T-Mobile store, they have magenta, that is their trade dress. University of Texas has a burnt orange color, that is their trade dress. Trade dresses are considered a form of trademark, where you give a certain look and feel that's associated with your brand.
Yeah, okay, good.
And maybe just that, in tying in with that was, remember we're talking about logos?
Oh, yeah. Can you talk about logos before we hang up about
So if someone has a similar
logo? Yes.
Mhm.
Remember
Yeah. Also, there seems to be the call-in. There seems to be a question from the call-in. I'll answer this question, and then we can take the question from the call-in user. So yeah, logo also has to be distinct. It can't be confused with another business's logo. So that's the general rule. So when you file for a logo, you have to do a search to see if there's something that looks similar to you. One quick way to just do it by yourself is that when you create a logo, do a reverse Google image search. Put it out there on reverse image Google. If somebody has something similar, if Google gives you some search results, then you'll know that, oh, maybe somebody else has something already out there, and I should change mine up so that there's no confusion with this other logo.
So I know we're going on a little, but that reminds me of something I deal with all the time, where companies come and they have similar names or the exact name. So I had one company, she had this odd name, and I said, how did you come up with that? And she said, well, she combined all three of her names to come up with this name. But when I Googled it, it was actually the same name, as a publicly traded company selling the exact same thing she wanted to sell. And she didn't understand why I said she should change it. So having similar names in the same industry is also a problem.
Yes, yes. So having a similar name is definitely a problem. Having a similar, you're allowed under law to have a similar name in a totally different industry, because then there's not a risk of public confusion, and so that's allowed. And in some cases, if your name is similar to somebody else that exists, and let's say you both sort of created it around the same time, you can enter into an agreement, if the other side is willing, to allow you to have your name in the same industry, subject to certain restrictions, usually geographic. So for example, there are two Hershey chocolate companies. There is the national brand that you know of, and there is an ice cream store in Hershey, Pennsylvania that has the exact same name. And those two companies basically had a lawsuit like 40, 50 years ago, decades ago. And they just agreed, fine, Hershey chocolate, we get to use this for our chocolates. You can use your ice cream, but you can only use it in Hershey, Pennsylvania. So you can Google this. It's a famous case taught in law schools of that type of agreement.
So can we go to the call-in person?
Yes, yeah, I see a hand raised for the call-in user.
Can you want to talk?
Make sure to unmute yourself.
Yeah,
Can
there
you
you
hear
go.
me?
Yes.
Hi, I just wanted to know if you can send out your contact information and what you specialize in if we need to use you down the line in our own business.
Sure, yeah, thanks. I think Robbie probably maybe can send that out, or
Yeah,
yeah.
Crystal will send it out.
Yeah, Crystal will send it out. Yeah. So our firm Luminate Law, we're a business law firm. It's me and my partner Elijah. He handles litigation. I do most things transactional, meaning I don't go to court. So I help form businesses. I do a lot of contracts. I do a lot of compliance, and I do a lot of general advising where people have questions about the law and how related to their business.
Yeah, and I'm sorry I forgot to introduce you in the beginning. So I love, so Dean, I've known Dean for a number of years. And one of the things I love about Luminate Law is you can go on their website and see their prices. How not very many attorneys do that. And he's really easy to work with. Elijah's killer. So if you need litigation, Elijah's your person. But no, these guys have been great. Unfortunately, you're on Oahu, but it's easy to work with you even though you're so far away, or a 20-minute plane ride. That's not
yeah. Well, I have clients all over all the neighbor islands and also on the mainland, because I used to practice on the mainland as well. And nowadays, with Zoom, it has made things easier. We used to have an office downtown. We actually just closed our office in February this year because nobody wanted to meet in person anymore. We do everything on virtual.
That's good. So we have one more question.
Few more questions.
Two more questions, if you can hang on.
Sure.
Okay, go ahead.
While we have you on the phone, you were talking about how if you create something and the minute that you create it, you have a copyright. But then if you get it federally copyrighted, then you can go after somebody for monetary damages. But what benefits do you have just by creating it and copywriting it that way, like on that level?
What benefit? Sorry, the last part. Did you repeat that last part again?
By just the copyright from creation.
Instead of paying for a copyright, is it? I mean, you still have the same benefits. The only thing, from my understanding, you can correct me, is that you would pay for a copyright if you wanted to go after somebody for infringing on you.
Say that again.
Say I took all your artwork and I duplicated everything, then you would file for a copyright, and then so you could go after me.
Okay, so it's already copyrighted, but you have to officialize it.
Yeah.
Basically, is what you're saying.
Is that?
Yes, that's right. So you're right. When you create the artwork, it exists automatically. But if you want to sue someone for damages under the Copyright Act, you have to go register it. Now there might be other state law claims, other claims that specific to your thing, to your case, that may not require registration, like business, deceptive advertising. There's other types of other claims that you can make, but to sue under the Copyright Act for copyright infringement, you have to have registration.
Okay, so you're technically copyrighting it by creating it, but if somebody replicates it, then you have to do 2 steps ahead.
So like my mom is a great artist, and she copied all the great works, you know, so if anybody ever found her, then she could, you know, get sued, but nobody did, and she was really just like spot on. So what's your question?
I wanted to know what you think about, like, you know, if you are a pastor and you join or create a nonprofit, are you tax exempt?
Oh, if you're a pastor, okay. So there's well, yeah. So nonprofits are tax exempt. So there are 2 types of nonprofits here. So the IRS has a special provision for churches. Churches don't have to go get a 501c3 registration to be tax exempt. They are automatically tax exempt by virtue of being a church. But you have to meet certain requirements of the definition of a church. If you Google church IRS requirements, the IRS has a list of things that you have to meet to be considered a church and be tax exempt. If you create a nonprofit that's not a church, so meaning that it's not involved in ministry, you're doing something else. Let's say you're doing education or feeding people who need food. Those are not considered that's not a church. That's like a nonprofit. You have to go get a 501c3 designation that requires filing a form with the IRS to receive that nonprofit designation.
You guys in the back had a back?
Yeah. What is your take on poor man's patents?
What is that?
Formats that what?
Yeah, when I was doing some graphic design and stuff, I was told to take all my logos and have like 5 different versions of it, and you put it in an envelope and send it to yourself and don't open it, so that if anyone were to try to dispute or take your stuff or take you to litigation, you have an unopened piece of mail that has all the original stuff in there, dated, description, and everything. And I did that.
Yeah, so some people do that. It wouldn't work for a logo. So something like a logo or trademark or trade name, you have to use it in commerce. So what defines it is that you've put it on the website and you've shown it to the world that, hey, this is my business. This is my logo. I use a logo on my business card. I use a logo on my letterhead. It's on the signature of my email. I'm doing business under this logo. That is what establishes your right. So that is a trademark. The envelope thing, people have used it in terms of written work. So people have tried to use that technique to write a novel and put it in an envelope and mail it to yourself. So you have the sealed envelope that shows that's stamped, that says that you've done that at a certain time, and it is a piece of evidence. It won't be the thing that makes your case a shut case. Really, in those types of copyrights, when somebody steals your work, there's usually a paper trail. They came to your workshop. They got a copy of your manuscript at this point. Those are the things that will be established in a court case when somebody steals your work. How did they get it? And how what they did after coming across your work.
So does the con person still? You have your hand up still, so I didn't know if you have another question. Yeah, okay. No. Okay, great. So, Dean, I want to thank you for taking time out of your busy schedule to talk to us. I think everybody really got a lot out of it.
Great, thank you for having me.
Yeah, we appreciate it. Thank you so much.
Thank you.
All right, well, take care.
All right, have a good day, everyone. Bye.
All right, bye.